Recording is live.
Good evening, everyone. Welcome on behalf of International Commission for Human Rights and Religious Freedom. This is our third fellowship training seminar, and it is a new initiative on behalf of the International Commission for Human Rights, these fellowship seminars. This slide actually shows our logo. I hope all of you can see it. This is the logo of International Commission of Human Rights. And distinguished faculty for Professor Ved Nanda Fellowship Training Program in Human Rights include Professor Ved Nanda, Professor Yashwant Pathak, Professor Nalini Rao, Professor Lavanya Vemsani, Dr. Shekhar Patel, myself, Dr. Adityanjee, Mr. Carl Clemens, our very energetic Executive Director, and Mr. Hardam Tripathi, Esquire, our Director of Legal and Policy Affairs. At this point in time, starting from January 1st, we have two fellows currently, Mr. Ankit Shah from Gujarat, India, and Mr. Ripudaman Pachauri, who is based in St. Louis, Missouri. Now, the topic for today's seminar is History of Human Rights Movement. It is scheduled today, Friday, January 21st at 9 p.m. Eastern Daytime. This is Saturday, January 22nd, 6:30 a.m. India time. And our fellow, Mr. Ankit Shah, is going to be making the presentation on history of human rights movement. I believe that he has a nice PowerPoint presentation for approximately half an hour or so. So without further ado, I will invite our first Human Rights Fellow under Professor Ved Nanda Fellowship, Mr. Ankit Shah, to give his presentation on history of human rights movement. Ankit.
Thank you, Adityanjee, Professor Nanda and Carl for hosting this fellowship training. We straight away start with the presentation. On the very first fellowship seminar, we had covered the International Covenant and the history and the background of the human rights movement. So today I'm bringing some new perspective to this, a corporate perspective to this. So let's begin with the presentation. So we already covered the international covenants, the ICHR Declaration on Human Rights the previous time, and the history, how ancient India, the ancient US, and the European history covered in the Bill of Rights and various documents, various concepts of human rights. So today, if we summarize where exactly the human rights are derived from, I mean, in terms of practical lives of the people, of the citizens world over, you have on one side you have the Universal Declaration of Human Rights, and on the other side what you have on paper, something guaranteed by the state. So when we talk about on paper something guaranteed by the state, we realize that the constitution of the countries is something where the human rights are guaranteed in various forms. Now, if I am to chalk out some of the outliers here in terms of human rights, you would come to know that some of the nations who believe in religious doctrine at the top, even above the constitution, and sometimes the constitution being having elements of this religious indoctrination inside. There are some states where you will find, say, suppose if we are talking about, for example, Pakistan, where where Islam is the majority religion and Islamic doctrine is considered as the state doctrine, wherein you will find that several categories of people, say, for example, Ahmadiyyas, would not be considered equivalent to the Muslims, right? So when we talk about human rights domain, the overall umbrella, and something confirmed from a draft document of, say, something like constitution, then these guarantees varies country to country in terms of the application of human rights by the state. So on the one hand, you have this something which is guaranteed by the state. On the other hand, something which we considered as universal rights for all living beings on this planet, and something which is drafted as a Universal Declaration of Human Rights at the UN. Now, if I'm supposed to give you examples of general coverage in terms of human rights, freedom of speech and belief, right to life, liberty and security, peaceful assembly and association, and peaceful assembly covers, you know, uh, peaceful protests also by the citizens, freedom of thought, conscience and religion, equality before law, equal protection of the laws, and remedial action in case of violation, freedom of movement. Now, in Corona times, this is something which is worth thinking about. And now, how much of a freedom of free movement of a person, whether it comes above or below the right to life of someone else, right to safety of someone else. So these are some of the deliberations that one human right overlapping the human right of someone else or something like that. So this is something to consider about. Rights to health and well-being, right to own property, right to marry and have a family. So these are general examples of human rights which are um, uh, you know expected. Now, when I talk about human rights, there is a democracy connect to it, the format of democracy, if I'm talking about. So this is established in the UDHR, wherein it's clearly stated that government, by the consent of the people, expressed through periodic elections, is a basic right of individuals, and that the people have a right to participate in the government directly or through their representatives. So we find there is a fine connect made to the democracy format and the human rights in the UDHR, right? Now, we also know that not all countries are democratic on this planet. So this is something that we need to note. Now, Francis Fukuyama asserts that the ideal of human rights constitutes the most perfect contribution towards human dignity. So this concept of human dignity, which also has clear mention in terms of the ancient dharmas of ancient Indian civilization. It is the liberal democracy that provides the ideal conditions to safeguard human rights. So democracy format has much to do in terms of how much of human rights can trickle down in a nation, and how much of benefits the citizens can have. Now, I would like to connect this with something what I call as the recent phenomenon of globalization. When we talk about globalization, we understand that this is about the free movement of men, money, market, machine, right? And this is across time and space, across geographical borders of nations. That kind of integration we are talking about, where the countries are dependent not just about the economies, it is about communication, it is about interconnectivity in terms of travel, road travel, air travel, uh, the points of communication in terms of ideas exchange, ideologies exchange, trade, right? So it's a kind of a world as one family in terms of the kind of integration that we have seen, countries depending on each other on various aspects. Now, how much of this has to do with the history of the human rights movement, and in terms of contemporary changes that these has brought? So if I'm to give you some example of how globalization functions, first of all, just to give you a background, if I'm talking about a smoothie, it takes banana from Colombia, strawberries from California, milk from Michigan, juice from South Africa. So you see how integrated each part of the world is in terms of clothing. Somebody would be having socks from Bangladesh, shirt from Thailand, jeans from India, and sweater from Cambodia. So Definitely, globalization has brought a lot of integration. And when we talk about integration, there will be exchange of what people understand in terms of what their human rights are in that particular region. Now, if I'm talking about this globalization, it particularly works in a format of a joint stock company in terms of these big exchanges which are enabled, right? So companies operate this across borders, different geographies, different cultures, and are gaining increasing influence and power through this profit maximization and wealth maximization objective, where they are able to uh, source their funding from multiple channels, wherever it is more cost effective to them, and they are able to operate in multiple geographies based on what makes sense in terms of profit maximization. So the important point here from human rights perspective is that the corporate are going to lack the element of emotion and human sustenance in terms of longevity of the kind of operations that they do, in terms of what how they are going to make use of all the factors of production, one of the major factor being humans, right, involved, not just in terms of, if you say, the concept of stakeholders. There would be employees, there will be society, and there will be consumers who are consuming the goods or services. And then again, humans are also involved in terms of which geography they are operating in. So what kind of resources, the natural resources, these companies use. So there are very few effective tools to prevent human rights abuses and hold some of these companies accountable in terms of the excesses they would be doing. Now people are affected and are left powerless and vulnerable, where these companies have a backhand agreement with the polity, or those who in charge in the governance of the state. Now there are natural environments which are exploited, unprotected, and have devastating long-term implications in terms of their rights. So I've brought some case studies. If I am to jot down, the last 2 centuries, we realize that there has been a massive use of crude oil reserves, crude oil, being excavated and used by countries all over the world for fuel purpose, for transportation purpose, and so on. So when we talk about, you know, a piece of geography where this, the crude oil excavation is going to happen, and the kind of the damage to the environment or the depletion of resources which causes the after effects to the humans living surrounding, not just about crude oil, it is about all the natural resources. So if I am to bring some case studies here, so this was the first case is about a large oil company which begins operations in Nigeria, and people living around this oil extraction region begin to voice their concerns with regards to environmental and worker abuses. Now, it is alleged that the company finances the military, who then conduct mass raids on these guys, so that they can quell this opposition, and then the human rights issues are do not come to the forefront. The leader of the group, who calls for justice, over here in this particular case, faced unfounded accusations on him personally and was eventually executed. So there are several these cases where globalization and this joint stock company format, which is able to override all the principles of human rights because of the connecting the polity, and with people those who are charged in governance, right? I would like to share with here another case. This is an official case, Viva versus Royal Dutch Shell. Now, Shell began its oil production in Nigeria in 1958, and worked with the government to quell opposition to its presence. Now, when an outside company is coming to your geography, it definitely has, a massive, investment carrot which is extended to the state. So, Shell financed and assisted violent military raids against popular movements by the Ogoni people who raised concerns with respect to the widespread poverty, inequalities, human rights abuses, and environmental degradation, which was rampant in that particular region during this excavation stuff. Now, Waiwa, this guy, the founder and the leader of the human rights group, called for a movement for the survival of the Ogoni people, the particular tribe which is who are living in that particular region. And he was falsely accused, arrested, detained, convicted, and executed by hanging in 1995. Now the case of Viva versus Royal Dutch Shell was brought by human rights groups and lawyers against Shell on grounds of human rights violation, crimes against humanity, and torture. These were the allegations which were put in this lawsuit. And in 2009, Shell agreed to a settlement of $15.5 million. Now the case in point, and specifically my question here is something which happens around 19. I mean, the company starts operating 1958. The abuses continue till 1995, and the guy is hanged in 1995 with false accusation. Then the lawsuits start, and in 2009 we see some glimpse of justice, and that too in the form of a settlement, a monetary settlement. Now, my question is, how far monetary settlement is an answer to the human rights abuses from, if I may say so, 1958 to 1995, that too in 2009. So these are the kind of serious questions we are facing in terms of human rights abuses in this modern integration of trade and exchange and profits and the joint stock company formats operating all over the world. Now, let me share with you another case. And then my question is, what are the pros and cons of this settlement amount? I mean, does this make, is it even, a fair justice to say that kind of an amount, right? Now, this is a case of a large American beverage manufacturer who has partner factories in Colombia, and both the beverage corporation and the partner companies face charges of directing a paramilitary group in the intimidation, kidnap, and murder of trade unionists. Now, in this particular case, what has happened is uh, the people surrounding the region and the labor union came together to oppose. And the allegation here is that the corporation was able to, use paramilitary groups for intimidation, kidnap, and murder of those who are opposing and accusing the human right abuses in this case. The court dismissed the case against the corporation on the grounds that the events are geographically too far removed from the corporation's headquarters. Now, so the argument in this case in point is that uh, the the abuses happen too far from the headquarters of the company, and that is how the justice was done. Now, how far the legal framework has this? If I may ask, what kind of tools does the legal framework has to even make space for the human rights concerns over here in such cases, where if you are applying a particular blanket formula that the corporate headquarters is not situated somewhere around where the abuses happen, right? So these are some of, and countries like Colombia. So there are several pockets worldwide where uh, you won't be able to, I mean, there is no mechanism where you can ensure that what is enshrined in the UDHR, or what is agreed all over the world in terms of universal human rights, are even made to have some kind of an application, right? So these are the concerns. Let me share you another case. This is of Coca-Cola. Now, In 2001, Sinal representing workers in Colombian facilities, brought an action alleging Coca-Cola's complicity in human rights abuses committed by Colombian paramilitaries against trade unionists. So I did give you a background that when these massive, giant corporate machines enter your nations, they have uh, the benefit, or I should say this privilege of a massive investment potential, which is how the polity and those charged in governance act in nexus with them. Now, in this particular case, the allegation is that Coca-Cola is able to use the paramilitary against the trade unionists. Now, the claims outline various human rights abuses, including torture, kidnapping, unlawful detention, and murder of Sinal leaders and members. Now, the case against Coca-Cola was dismissed in 2003, and the court ruled that the abuses were again too far removed from Coca-Cola's headquarters in the US. Now, if I'm to bring some contemporary perspective to this, you will find that various countries of the world are facing something similar in terms of right to free speech, in terms of social media companies who have a headquarters in some Western nations, right? So some of these countries have concerns that the users on the social media platforms are blocked or taken action against by people sitting in some other nation where the headquarters is located. What about the freedom of speech guaranteed by the constitution in terms of human rights of the citizens of the states of these countries? So these are some of the contemporary concerns. I'm deriving this concept from this court ruling over here in this particular case, that the headquarters is too far. How much of sense this kind of, an angle of justice makes. Subsequently, the case against two of Coca-Cola's Colombian bottling companies were dismissed in 2006 also. The court held that the plaintiff's claims did not suffice to find war crimes under international law and failed to draw a close enough connection between the Colombian government and the three defendant companies. So there are three companies in this particular case. One is Coca-Cola's headquarters and two of the Colombian bottling companies. So three companies in all. And the fourth party, the allegation, facing the allegation is the government over here. And all four of them, acquitted without, you know, any sense of uh, clear justice, as we can see in this particular case. Now, so the question over here is, how do we draw the line between a corporation's apathy with regards to government action versus corporation support of government action, where where the government or or some of the people charged in governance are hands in glove with the corporate giants uh, who are enabling this human rights abuses. We need to draw a line somewhere. For this is the pertinent question which I am posing today. So the question is, where do we go from here, and what can we do? So I have some of the suggestions. So we should make people aware in terms of human rights issues everywhere. What's in the news? Raise awareness, talk to family, friends, teachers, those community people, guys who can lead and take charge of these discussions. Spark a dialogue wherever you are able to trace human rights abuses surrounding your environment. Become a member of a human rights group. Um, Advocate, write to the government, speak to the community leaders, uh, be your own voice, be conscious of the everyday life, notice where your clothing and food comes from. If I'm to cite some companies like Hike Vision, which sells cameras, Now there are allegations that this is the company which, has some governance control in the with the Chinese Communist Party, where the same company is using the same tool for human rights abuses to Uyghurs and some of the Chinese citizens, keeping 24/7 surveillance on them, and blocking many of the human rights within China. Now, how much are we to buy these products in other countries? And are we indirectly sponsoring these human rights abuses within China? So these are the kind of questions. So we have to find out where our clothing, food, and what products we are using, where they come from, what kind of companies and what kind of historical background these companies have, uh, at their point of origin, and even elsewhere, where they are able to exploit some of the human rights of the people. Think about it, and how we can move forward about it. Question is, how this abuses happened, who was involved, what is the impact on other surrounding human beings and the natural environments. Do not forget the natural environments, because if someone is treating human beings wrong, uh, obviously we can take from there that they are not going to be treating the natural environment good either, right? So these are the resources for the presentation, and I think I'm done for the day. Thank you.
Thank you, Ankit, for your presentation. Just wanted to notice that Ripudaman Pachori, our second fellow, has joined. He is not on camera, but I think he is probably listening to it. I don't know why he is not on camera. Ripudamanji, if you want to join on camera, that'll be good. Somehow, Ankit's presentation today was more about contemporary challenges rather than the history of human rights movement.
We
And
covered history the first session, right?
but having said that, I'm going to a little bit go back to the history of human rights movement in today's discussion before we go on to question and answers. So in the first seminar, we talked a little bit about international covenants and how the issue of human rights came. And Professor Nanda talked about the concept of human dignity besides human rights. I take this as a kind of, diamond, human rights diamond, or human issues related diamond with four corners. On one corner is human rights. On the second corner is human dignity. On the third corner is human duties. And on the fourth corner are human responsibilities. And they go hand in hand. And as far as the human race has existed, all the societies have been sort of challenged with these notions of human rights, human dignities, human duties, and human responsibilities in one way or the other. The language, the diction, the vocabulary may have been different, but we have discussed these issues since the human race has existed, because human race is a socialized race. We don't live alone. We live in actually groups, families, communities, cities, states, nations, and that has been the history. So there's nothing new about human rights movement starting, with Universal Declaration of Human Rights. It's not true that the concept of human rights was not there. However, we have a very lopsided view of human rights at this point in time. And when we talk about human rights, at this point in time, it is portrayed as if it is rights of an individual against a state. That's the current notion of human rights. But in this broadened discussion, not only we need to bring the issue of individuals' human rights, but other parties involved, human rights of a community. So Ankit, in today's discussion, we talked about the Nigerian issue where Ogoni tribe was involved. So what about the rights of Ogoni tribe there? Their natural environment was being sort of, disturbed by this Shell Oil company. Now, in today's discussion, it's a binary discussion, individual versus state. Can human rights violation be done just by the state? No, not necessarily. It can be done by non-state actors. In Ankit's case study, it was Dutch Shell Company. It's not a state actor, it's a non-state actor. Similarly, Al-Qaeda is a non-state actor. So terrorist organizations are non-state actors. So are the corporate sectors, entities. They are non-state actors. They use the power accumulated either by economic means or by terrorist means to violate the human rights. So when we have a discussion of human rights in contemporary situation, we need to consider all the actors that are involved, individuals, families, community, state, and non-state actors. There is a kind of contrast how people in the West talk about human rights and what is the conceptualization of human rights in other countries, especially East versus West. Historically, when you talk about East versus West, there's a difference in nuances. So people talked about, human rights concepts in India. If you look at ancient Indian literature, you would not find much in terms of adhikara, but everything will be about a code of conduct called dharma. Dharma personified the concept of human rights, human dignity, human duties, and human responsibilities. So starting from Vedas, there was a concept of dharma which included obligations and rights. The sense of righteousness, what is right for one individual. Concept of responsibility was enshrined in the concept of karma. And what was the role of the state? The role of the state was Rajadharma, duties of the ruler. Rajadharma was the code of conduct or rule of law that was superior to will of the ruler and governed all his actions. So even the king was, not the highest authority. The state was not the highest authority. There was Raj Dharma, which was codified, and the ruler was supposed to follow his or her Raj Dharma, which means the ruler or the king could not be the autocrat, which is slightly different from the role of king in the Western Hemisphere, where king could legislate, king could decide everything. In Eastern civilizations, the dharma, the code of conduct was, accepted unanimously after some debates amongst the learned people. They created the code of conduct called dharma. So there's a, in Manusmriti, the great lawgiver Maharshi Manu has beautifully described dharma as dhriti kshama damo asteyam shaucham indriya nigraha dhira vidya satyam akrodho dashakam dharma lakshanam. So perseverance, forgiveness, self-restraint, not to steal, not to take possessions of other without permission, internal and external purification of senses, control of senses, improvement in your own intellect, acquisition of knowledge of vidya, attaining truth of satya, and abstaining from anger, akrodha. Now, this applied to an individual, this applied to an organization, this applied to a ruler. So there were concepts of code of conduct which people were supposed to follow. Kautilya, in his famous Arthashastra, wrote, happiness of the people is the happiness of the king. Similarly, you have Ashoka's edicts, which were distributed far and wide, and they actually gave the laws how to, make the praja happy or what they were supposed to be doing. If you see the Western Hemisphere, the earliest laws were Code of Hammurabi. King Hammurabi of ancient Mesopotamia. Although his law code was not the first, it was clearly most defined and influenced by laws of other culture. In ancient Mesopotamia, there were other codes also. Code of Arnam, this dates back from 2100 BCE in city of Ur. These were laws written by a king who ruled over a homogeneous population, and they were, operating from a standard recognition of what was expected of the citizens. Yes, we may not actually sort of agree with all the laws, because Code of Hammurabi basically talked about eye for an eye, the biblical justice. Uh, so that was there, although it was not appreciated, you know, in the current human rights movement. So pretty much what I'm trying to say, that all the civilizations had some codified laws or regulations that govern individual conduct, that govern the conduct of, people who violated the laws, and what was the law of the king. But slight difference in Eastern civilizations was that king was supposed to follow a law not codified by the king himself, by other learned people. Afterwards, there were Akkadian kings who also gave their laws. There was Mosaic laws, and then you were following the sort of, appearance of the religions of the book. There were certain codes, biblical codes or 10 commandments. If you look at classical Greece and Rome, there were thinkers, there were political philosophers like Plato, who talked about natural justice. In fact, Plato wrote a book called The Laws. Aristotle wrote a book on politics of Nicomachean ethics, and basically says that the rule of law is necessary for good government and interests of the individuals. Similarly, Cicero talked about codes of laws. If you look at China, ancient China, there were, certain codes of conduct given by Confucius. There was focus on responsible behavior towards others and to the best of one's capacity. There was another Chinese philosopher, moral philosopher, called Mo Tzu, who gave Mohist school of moral philosophy, and later day Confucius, shishyas or students gave their own sort of, explanation of human rights, concepts. So one of them, called Mengzi, talks about all human beings sharing the same humanity and same set of predicaments. I think the problem came in the medieval era, when there was too much of, sectorization in the Western society following the Abrahamic religions, which started believing in speciality of one class or the other. Ancient people had talked about, sharing all humanity having the same predicament. But after the arrival of books that codified the religion, there was othering of sections of populations. So what happened that, this othering led to violation of human rights of those who had been othered, those who had not subscribed to the same religious philosophy, whether it was Bible, whether it was Quran. The religion was used to violate the religious freedom and human rights of other human beings. Although in ancient times the same thing was not there, everyone was supposed to be, similar, facing same predicament and all that sort of thing. So we see that in terms of human rights movements, there was a deterioration in world situation with the arrival of religions of the book. And that's a reality, because when you divide humanity into us versus them, it's an inimical adversarial concept. And that adversarial concept led to colonization, European colonization, genocides, uh, colonization, usurping the lands of, in other continents, whether in America, whether in Africa, or in Asia. Now, simultaneous to this, Magna Carta came, and that shows the evolution of democracy actually in Britain, and its subsequent, Oliver Cromwell's, edicts and things like that. So the history of human right movement is very complex, which just should not go to post World War II situation that's the arrival of human rights movement in the world or in the Western world. Actually, I would look at the post-colonial world or post-World War II era in a different situation. So if you see World War II, there were human rights violations. And these human rights violations were by every party. If you look at Axis powers human rights violations, of course, the Nazi regime did numerous human rights violations, including genocide and Holocaust. One does not need to talk about that. But what is not appreciated that other Axis powers, including Benito Mussolini in Italy, had the same levels of human rights violations in Italy and the Italian, you know, imperial empire in North America, North Africa, and other African countries. Fascism or fascist philosophy did not give any human beings any right. It was the will of the ruler that decided. Unfortunately, because of the enormity of the Nazi human rights violations and Nazi, Holocaust, nobody talks about Benito Mussolini's actually human rights violation. Similarly, the third Axis power, Japan, did conduct human rights violations, is guilty of human rights violation all over Southeast Asia, the Southeast Asian countries that they conquered. And, Burmese railways where slave labor was used from India and captured British soldiers was one example of that. In fact, it is alleged that Japanese soldiers in Burmese railways and in Southeast Asia indulge in cannibalism. So none of the Axis powers covered themselves by glory. Now let's look by Allied forces human rights violation in World War II. Around the same time in this country, in United States, there were Tuskegee experiments going on. Now, not very many people know because that comes into the history of medical ethics, evolution of medical ethics in this country. But in Tuskegee experiments, for decades, African American citizens of this country were denied treatment for syphilis, although the treatment was available, because the medical scientists wanted to study the natural course of syphilis without treatment. In fact, antibiotics were denied to minorities, and even in the armed forces, antibiotics were denied to people who were severely injured in the war. And they were used to treat the soldiers or treat the able-bodied citizens who had contracted actually sexually transmitted diseases so that their disease can be treated and they could be sent to war. So there was again, othering of one group versus other. There were numerous bombing of civilian populations by the Allied forces in Europe, in other countries. And the pinnacle of this human rights violations was use of nuclear bomb for the first time in Hiroshima and Nagasaki. Now the argument is given, a moral argument is given for use of nuclear bomb that it stopped the World War II. You could say that for the first nuclear bomb explosion in Hiroshima. But once you had wiped out a city in Hiroshima, there was no moral, military, or ethical justification for use of the same nuclear bomb 3 days afterwards in Nagasaki. And that was one of the gravest human rights violations in the history of contemporary world. So in Western societies, which are it's very fashionable to talk about human rights violation. From a psychoanalytic point of view, there's a civilizational guilt. Having committed these civilizational crimes in Second World War and post Second World War, there's a societal projection to other societies that they are the ones who are violating human rights. We are the protectors. There's a reaction formation in psychoanalytic terms. It's a counter reaction that you are taking extreme positions on human rights rather than taking a balanced position. So human rights, movement in Western world in post-colonial, post-Second World War era is an aberration, and it is not a balanced proposition. If you see societies that were cognitively advanced, like ancient Indian society, they talked about, not just adhikara, but the dharma, the dignity, the duty, karma, responsibilities, everything I talked about, the diamond of human rights. In the West, in contrast to that, there's a very piecemeal approach. So on one hand, you talk about human rights movements, you talk about feminist movement or women's rights movements, but it is the Western countries that did not give universal suffrage to women. In the United States, women got right to vote only after 1949. Now we have another aspect to it. Animal rights movement, what PETA is doing, again taking very extremist positions. But when you see the ancient advanced civilizations, they just didn't talk about rights of humans. They talked about rights of two-footed living beings and also the four-footed human beings. The prayers were said not only for those who had 2 feet, but chatushpada also. Those are the animals. From time immemorial in Eastern societies, we have revered the Mother Earth. And after actually exploiting the environment, exploiting the resources, leading to a situation when we have global warming, we have lack of sustainable development, and we have so much of pollution. The Western approach is now talking about environmental protection in humans, which is again part of the human rights movement. So what you see is a piecemeal approach rather than a holistic, universalistic approach. And hence, my thesis is that Western human rights movement is highly defective. What has happened is that there is intellectual colonization that has replaced physical colonization of all the countries. Human rights have been weaponized for continued colonization by other means. We are using instruments like IPR and TRIPS, intellectual property rights, to continue to colonize. We are talking about vaccine divide at this point in time. People in Africa don't have vaccines. The pharmaceutical companies are not willing to give, licenses to manufacture vaccine in those countries and want to basically continue to make their profits. Now, compared to the Western world, you look at communist bloc in Soviet Union, there were massive human rights abuses. Similarly, in communist China, you had cultural revolution, you had great leap forward, you had approximately 40 million people that were slaughtered as part of the cultural revolution and great leap forward. So if we look from a globalistic point of view on human rights movements, the the little waves here and there by the Western philosopher, Western politicians are really self-serving. The concept of human rights has been enshrined in ancient civilizations. As far as medieval societies were concerned, there was detriment, there was decline in concept of human rights, which was direct relation in relation to ascendance of Christianity and the other religion of the book, which led to slaughter of multiple thousands and millions of human beings over the entire centuries, at least 10 centuries or so. And after the Second World War, there was some guilt feeling created in the Western world. So you tried to come out with Universal Declaration of Human Rights in a very lopsided manner, and then you use these things as an instrument of oppression of other countries because you want to continue to maintain your own supremacy, as Ankit Shah talked about the corporate world and things like that. So consider the concept of Vasudhaiva Kutumbakam. Actually, the original, the verse is Ayam Nijaha Paroveti Ganana Laghuchetasam Udara Charitanam Tu Vasudhaiva Kutumbakam. Ayam Nijah, this is mine. Paroveti, that is others. Ganana Laghuchetasam, that's the counting of people with small hearts. For broad-hearted people, everything in entire world is their family. Compare that to the globalization that Ankit was talking about. Globalization is nothing but McDonaldization of the world. What is happening? That you have a philosophy of Vasudhaiva Kutumbakam, and if I may create this word, Vasudhaiv Apanam. I think Carl will know what I'm trying to say. So Vasudhaiva Kutumbakam, the word is my family. Vasudhaiva Apadam means word is my market. And you're trying to capture the markets. So I think we have to understand the history of human rights movement in various epochs and see how it relates to today's condition. I was a little bit concerned that today's discussion, the way it started, was more on contemporary issues rather than the topic, which was history of human rights movement. But we are open to discussion now.
I had one question, both for Dr. Adityanjee as well as Ankit and others. So, we talked about how corporates are given the status of a person legally and how that is being abused because, typically the corporate is just clinically thinking about the bottom line and so forth. But recently, also in a couple of countries like New Zealand, there's been a move to declare like a river as a person that has its own rights, like a river. How do you see that panning out? Do you think that's a way forward? Because it's hard to define, and in terms of a legal, from a legal perspective. So, how do you see that kind of panning out? Do you think that would balance things out? Do you think that's the way forward, or what would be your comments on that?
Ankit, do you want to go ahead?
Yep. So, my understanding is human rights is not something that you can separate from the rights for all the other elements on the planet. So the very start of thinking that human beings are going to be some isolated portion on this planet is something which is a wrong concept to begin with. So, but since this concept of human rights in terms of putting it on paper and making it applicable worldwide started with the Western template, that is where the fault lies. So all the countries who believe, and especially the pagans and the indigenous cultures who believe in integrating with all the elements of earth and living a life along with that for eternity, I think they have to come forward and put up their stuff for the world.
So, Carl, in answer to your question, if you look at situation in India, uh, besides human beings and corporate entities, a lot of other institutions have been given legal status by judiciary in India, including certain deities. And at least in that culture, in Sanatana Dharma, rivers are persons. And that's why, the courts are taking cognizance of pollution, and you have, things like Namami Gange. So Indian judiciary has given some of the rivers the status of a judicial person. And I think it's a good concept because rivers are rivers are living phenomena. They are living ecosystems. And if we pollute those ecosystems, we are doing genocide. You know, travel agencies are now boasting that you can see dolphins frolicking in Ganga. Why? Because the ecosystem of River Ganga has been regenerated. So I think these are good efforts to balance and correct the situation. And I think all such efforts are welcome, where they come from New Zealand or Australia or wherever. But I think they are also already existent, those kind of examples in other countries as well. And I don't care, whoever is doing this, as long as it is good for the environment, good for the ecosystem, good for the whole planet, it's a good measure.
Just to add to this, there were some concerns about companies saying water is not a human right. so, so it comes from the opposite spectrum completely. Now, how much of this gets the support of the state in terms of doing business and profitability and investments and parking of stock market finance, etc., etc., etc. This is completely a opposite spectrum of looking at things.
Uh, I think we'll invite some comments and considered opinion from Professor Nandaji on this issue because he's very much involved. So,
Well, thank you. Ankit congratulations. You did a wonderful job. And
Thank you.
as Adityanjee mentioned, human rights is pretty vast. And all the ancient traditions, their perspective on human rights has a great deal of validity. And just 2 years ago, a book on all religions and ancient traditions and human rights in that, and I had a chapter on human rights in ancient India. And it's a book that you might want to look at. It just gives you back, as Adityanjee very eloquently presented, about all these ancient religions, ancient cultures, and how they have looked at human dignity and responsibility and duty and dharma as the basic concept. I think it will be good to glance at that. But point simply is that, as you rightly mentioned, today the only game in town is the current human rights. And the current human rights tradition back Universal Declaration of as today. Focus of your discussion today was on simply liberties and freedom, and that is against the government. And as Adityanji mentioned, you go back to Magna Carta and you move on. And all the Western tradition was that the king is the one who is oppressing it. Let us get rid of him, or let us put some constraints upon him. And that is how, from Magna Carta on until now, the tradition has been liberty, freedom, individual, that is going to have some limits put upon the government so the government is not repressive, and therefore due process, equal protection, constitutional guarantees. That's what has happened. I won't go into any details, but I think the points that you made today, and you presented the current human rights and the current human rights traditions, I think you might keep in mind, and obviously you did a wonderful job. But Sara Viva and the issue that came up about corporations, the point simply is, where do you bring the case? And then, as the Carl mentioned, Sir Carl raised the question about rivers having a standing. 40 years ago, one of our colleagues at the University of Southern California began this process asking, do stones have standing? Can they bring a case? And then at the Human Rights Council, many, many years ago, the question came, environment and human rights, how closely are they connected? And then the question was, when you talk about the environment, are you looking at human beings? And in the human right tradition, that environment gives you right to health. Human beings need health, therefore environment is good. Human beings want to live, therefore we don't want to have environmental degradation. But the point simply is that under the legal system, in order to bring a case, you have to have a standing, quote unquote standing. And should the environment, qua environment, be protected, or environment be protected only because of human rights of human beings? That has been under discussion for a long time. But as you presented the cases, and then I go back to your cases, Sana Viva, he brought a case in the United States, and the case went to the Supreme Court. And the point simply is that at this stage, in this country, there is a law that says that any alien can bring a case in the United States on an issue that pertains to human rights violations. And that is a very, very special setting in which you can, in the United States, bring a case. But in the world community today, the only way that you can bring a case is when you can say that under international law, there is a possibility that you can say universal jurisdiction. And universal jurisdiction is the one that Germany in the last week has decided a case against the person who committed torture in Syria. And so Syrians, a couple of them have been now indicted and punished under universal jurisdiction. But not many countries are trying universal jurisdiction. So when you bring a case against a corporation, and remember, human rights at the present time is where human rights are, governments are the ones, non-state actors, as Adityanjee mentioned. Initially, there was no idea that you go after non-state actors. Because after Second World War, the only question was that countries are violating human rights, governments are violating human rights, put constraints upon them. That is the current human rights. And so, how do you bring a case against a corporation? Universal jurisdiction doesn't apply. So, the only way that you can bring a case against a corporation is that the corporation aided and abetted violation of human rights in collaboration with the government. That is how the case was brought against all these corporations, aiding and abetting. And unfortunately, in this country, the United States, today what has happened is that they have said that there is a presumption against extraterritoriality, that the United States law is not going to take a case in which there is no relationship with the United States. And if there's a corporation that's a US corporation, only then, and then there also, it's more than that. You've got to have a specific case, you have to have a universal case, universality, being specific, being obligatory. Those are the three standards. But in any way, those are all kind of details. But at this stage, against corporations, unless the corporation is incorporated in your country, only then you can bring a case against a corporation. And corporation does not commit crimes, individuals commit crimes. So how do you bring a case against a corporation? In any event, I'll send you a few things. I should have done that. I haven't done it, but I'll send you at the present time where the human rights movement is going. And if you want to look at the history of human rights as we know, understand contemporary human rights, then I think you need simply to look at the United Nations, the regional commissions and courts, and it's the European Commission, European Court of Human Rights, Inter-American Court, Inter-American Commission of Human Rights, African Court and Commission of Human Rights. There is nothing in Southeast Asia. There is nothing in Asia. There is nothing in the Pacific area, but it's at least three regional areas: Africa, Latin America, Europe, and the United Nations. And United Nations treaties, United Nations committees on those treaties. So institutions, norms, and processes. But in any event, as Adityanjee mentioned, it's a very, very vast subject. Are you talking about individual rights? Are you talking about collective rights? Do collective rights mean human rights? And so all that is kind of pretty vast. And unfortunately, to get a handle on all of this, we'll have to put a lifetime in order to understand that. I'm sorry I took much longer. I was going to take only a couple minutes to say a couple words about it.
Actually,
I'm done.
Professor Nanda, it's always pleasure to listen to you because you bring a
Thank you.
perspective which is scholarly, which is academic, which is up to date. So speaking in the same vein, taking on from Professor Nanda, the concept of universal jurisdiction is becoming more and more important. Professor Nanda talked about Germany, court in Germany taking case in Syria. Courts in Spain have invoked universal jurisdiction and have tried to bring human rights violation or, lawsuits against political dictators or autocrats or whatever in Spanish jurisdiction. So it is happening. United States, actually, the picture is very complex. United States laws do sometimes allow you to bring lawsuits, extraterritorial jurisdiction. But if you look at the overall picture, there's a little bit of hypocrisy in United States law or judiciary. So, United States judiciary has sometimes gleaned over human rights abuses of its own. One may not agree with the political philosophy, but for last 20 years, there are prisoners in Guantanamo Bay that have never seen the light of United States judicial system. Now, we can agree that they may have been involved in heinous crimes, but United States judicial system has utterly failed. And I think that is a reality. And people from United States judiciary or human rights community or Human Rights Watch or State Department or US ICHRRF who thump their chests about human rights violations in other countries cannot seem to understand how shameful it is for United States to have these people locked up in Guantanamo Bay and not being brought to justice, not even a single case. You talk about judicial delays in India. Justice delayed is justice denied. So United States is not the beacon of hope. Let's be very frank. They consider their political interests and the reasoning is given whatever the way. One thing about law is that law is never static. Law is always evolving. You know, whatever the contemporary standards are, somebody is going to go back and improve on that. And I will use the case study of India as an example. You know, the judicial system was very, very rigid at one point in time. And then judicial reform started, and totally a new phenomenon came. And that phenomena is now, of course, being abused. That is the concept of PIL, public interest litigation. It was not codified in the Constitution or in any law book, but it has become a norm to the extent that it is being abused. So law is never static. The concept of extraterritorial jurisdiction, maybe Germany adopts it, some other European countries adopt it, Spain adopts it. You might find that other countries start following the suit. So standards will continue to change. As far as corporate responsibility is concerned, you know, sometimes corporations are not brought to justice, or sometimes they are let with just a slap on the wrist, you know. $100,000 fine. What is that going to do? That's not going to deter when they are making billions of dollars in profits. There is one case study which impacts both United States and India, and that is Enron. You know, Enron had a history of starting that double, you know, gas/electricity project in Maharashtra. And they were involved in massive corruption and the way the contracts were written. And then Enron in Texas got into trouble because of their corrupt practices. Not only the company went under, but the business executives of the company, they are all behind bar. So corporations can take one stance, but it depends upon the circumstances. If the evidence of corruption is so blatant, not just the corporations wind down, but also corporate executives can be brought to justice, which happened very uniquely in Enron's case. Because besides Texas, they had done the same game in California in 1990s and early 2000s. So they had a track record of exploiting individual consumers and things like that, and having a kind of crony corruption with the politicians in cahoot, donating to their PACs. So although the legal systems in various jurisdictions are not competent enough to be able to prosecute the corporations, but this will become a trend that someday somebody will bring extraterritorial jurisdiction cases. And if those companies have assets in the country where the case is being brought, they can say goodbye to their assets, because ultimately it is the economic damage that motivates these companies. And with globalization and all that sort of thing, companies have assets spread around. So you should be able to target them for human rights violation.
I'm sorry, Adityanjee, my apologies. I have to go, and I'll send some universal jurisdiction and a couple other areas, some articles, and I'll send it to Karlji, and he can send it to everybody if he feels appropriate.
Sure, sir.
Thank you,
Thank you.
Professor Nanda. Thanks a lot
Thank you
for
for now.
giving
Sadhana
it.
Namaskar, everyone.
Namaskar.
Namaskar.
Thank you.
So next week's seminar is by Ripudaman Pachori. He will make the presentation. Mr. Clements is the faculty preceptor, and I believe it is on polycentricity and pagan religions.
Yes.
So we have started these seminars. It's a new venture for us, for our fellows. My request is stick to the topic at hand, because we will have future, if we kind of preempt the topic, we are, sort of overriding the future possibilities of some of these topics coming later on in the series. So if we stick to the topic, we will have better, more informed discussion rather than going on a segue or going on a tangent. So hopefully we will talk about polycentricity and pagan, religions. And I know Carl is the best person to be preceptor for that particular seminar because he has made presentations in World Parliament of Religions. And, in one of our, seminars, symposium, he was a speaker and he is already in the process of writing an article, evidence-based reference article on polycentricity and pagan religions in United States. So we should have very good discussion. For my fellowship trainees, two apples of my eyes, please be in time. It is very, very disrespectful to the faculty preceptors if you present late.
I apologize that, Adityanjee. But I do have some questions,
Sure, go ahead. We have
So,
time.
yeah, so one was related to the historical aspect of
Yeah.
this violation in the like modern history and in the contemporaries. Everyone knows, but in the modern history and the ancient history, were there any bodies that registered their protest and were successfully able to stop or kind of you know um, uh, uh, take action, force the state or non-state actors to stop those violations. So that is my first question.
Let's go one by one so that we can, deal with without forgetting or mixing up things. So as far as, let's say, in the Western concept, the king was the ruler, king was the ultimate ruler and maker of the law. That was not true in some of our Eastern civilizations where king also had to follow his or her Raj Dharma. So there was a codified, sort of code of conduct for the king. If king did not do this, king would be in trouble. Okay. And king will lose the position. Okay. Whereas in Western sphere, king would be overturned. Okay. There would be a rebellion. Why United States is United States of America? Because the king was, making profit by putting taxes on American people and even in British people, even the right to drink tea. British kings had imposed tea taxes. So king in United States, the British king was supposed to be a despot. That's why the king was overthrown. And pretty much in almost all the European countries, kings were autocratic rulers, but they also ruled with their minions, and there was always aristocracy or nobility. And they influenced some power, and by palace coups and things like that, if the king was really, really tyrant, king would be deposed and somebody else will become the ruler. That had been the tradition. As far as non-state actors were concerned, the king was supposed to exercise, at least in Indian tradition, Raj Dharma. So if somebody was violating the laws, king would bring that person to justice. And that happened time and again. That did happen time and again. Having said that, when we are talking about thousands of years of history, the social norms, the mores, the taboos, they change from time to time and there's contextualization. And we have to see in that context the conduct of people rather than, 2021 standards or norms. I think that is a fallacy if you try to judge ancient historical figures by today's standards because standards have changed. What is your next question, Ripudama?
So another question was you mentioned about the Second World War
Mm.
human right violations. Um, was there any case that was filed against the Allied forces after the Hiroshima Nagasaki?
No, and that is a fallacy. They were Nuremberg trials. Nuremberg trials were to hold the war criminals. And you know the dictum is might is right, victors write the history, victors write the justice and the laws. So Nuremberg trials were basically to try the war criminals. And in Nuremberg trials, there was an Indian judge who did give dissenting, uh, sort of judgment against Japanese war criminals. So Japanese people even today revere. I'm forgetting the name of that judge, but that judge is highly revered in Japan. Uh, Nobody has dared to bring a legal case, and it should not be allied powers. It should be government of United States for that. But there's a hypocrisy involved here. Marshall Islands brought a lawsuit against 9 nuclear countries, 5 NPT5 and 4 non-NPT5 nuclear powers in the International Court of Justice. And United States refused to be a party because United States does not, accede to the jurisdiction of the International Court of Justice. So again, the ultimate law is might is right. You can do anything wrong. United States did a lot of bombing in Serbia, civilian infrastructure, under Bill Clinton, under Madeleine Albright. Were they brought to justice? No. If anybody else had done, they would have been, tied up, brought to the Hague, and imprisoned. So you can do, you can arrest Ratko Mladic and the psychiatrist, I'm forgetting his name, the Serbian, Bosnian psychiatrist who was head of the state at that point in time, still in prison. But you could not bring to justice Madeleine Albright or Bill Clinton, who bombed the civilian infrastructure in Serbia as a way to force, you know, Serbian government of the day to sign the agreements and allow, recognition of Bosnia and Herzegovina. So ultimately, these things are not fully justiciable, and we should not consider law as the supreme. We also consider moral pressure, name and shame as an ultimate weapon for the history, because sometimes laws are not adequate. Nobody has brought, let's say, Mao Zedong to justice. 40 million people killed.
Okay, I have another question.
Mhm.
So, um, one is, can a country, a particular country, can file a case against the violation which is happening in another country, in the court of the third country. You know what I mean? Like country A is the uh, basically filing the case for the violation happening in country B in the court of country C, like when Nandaji was saying about the universal jurisdiction.
Uh,
So is it always a international court of justice? Always these courts are heard, or can it be heard in the courts of a
Private
particular country?
entities have filed lawsuits in third countries. You know, private organizations have brought, but for a government to bring a lawsuit for human rights violation in a third country would be loss of sovereignty. So they are not going to do that. If they are going to bring a lawsuit, it is either for commercial issues or violations of treaties. But if it is for, human rights violation, it has to go to pretty much the international court. And
Uh,
United States is not signatory to that, so it does not accept the jurisdiction of the International Criminal Court or the Hague Tribunal.
all right. That's all from my side,
No,
Adityanjee.
these are good questions for discussion. That's why we have separate time for Q&A. And so half hour, half hour, half hour. Half hour presentation, half hour discussion by the preceptor, and half hour Q&A. That is the format we are having. And since these are recorded things, I guess, Carl, we will be uploading these, or they are already uploaded on the website button.
Yes, no, we will be uploading. I'm just looking at some video editing that's to be done for some of these. And once I figure that out, I'll start uploading it this week.
So, Ripudamanji, you can liaise with Mr. Clements for the next week's seminar.
Right.
It will be a very good discussion. And as we come midway along this series, I will prepare the schedule for next 8 weeks. So my hope is that we will have this series of seminars for 6 months that will cover essential topics. In the next 6 months, both of you will focus on your project. And my hope is that from July 1st, we will have another additional batch of 2 fellows. So they will do the seminars while you guys focus on your research project. But the seminar format will still be available and you'll be able to join, but you don't have to prepare and present. The new fellows from July 1st will do that. So I think there's a good grounding of discussion and topics in seminars in which we take topic by topic and followed by, some time for your research project. So that would be a healthy balance.
Dr. Adityanjee, I know we don't have any time left, but I just wanted to throw this out there and maybe this will be a topic in future. But just about this idea of universal jurisdiction, as well as taking the whole ecology into consideration.
Right.
Ankit mentioned the right to water, for instance. So, is this going to undermine, the current Westphalian nation state? If we go that route, that's one question. The second is that, if you look at ancient cultures like the Dharmic culture, talked about your rights but also your obligations. So as long as you were a participant in that culture of dharma,
Yeah.
you had those rights, you had your duties, but then you had your rights. Similarly, now if we look at the politics of migration and demographic change and all these things going on, we have some countries, including many Western countries, Canada and Europe, Australia, which have passed laws that even if you're a naturalized citizen, but you're found to be linked, even indirectly, with groups related to terrorism, you can be denationalized. Your citizenship you can be stripped of your citizenship. So this push and pull between the nation state and universal human rights, how that is going to play out, that's something that's kind of interesting to me.
I think this is a valid question, but we are going through unprecedented times, and unprecedented times require new legal doctrines. Even the concept of Nuremberg trial, that was a new doctrine at that point in time.
Right.
Establishment of International Criminal Court was a new doctrine, new institution. Erosion of Westphalian state, sovereign state. Now you have WTO deciding what is happening. You have parallel example of EU leading to Brexit. So there is always a push and pull, how much you want to exceed. And ultimately it will be that the mighty and powerful nations will not accede to any universal jurisdiction, period. I'll tell you, we talk about this and that. In 1984, we had Bhopal gas Kand. What happened to Warren Henderson? there was collusion by the state government. He was arrested and then he was put on a plane flight outside India, and he never faced justice till the end to his death. And US court system refused to touch even, you know, lawsuits by the victims in US courts, taking very convenient, argument that Indian Supreme Court has already, you know, opined on this or ruled on this, as if they bother about Indian Supreme Court. So a lot of it is hogwash and hypocrisy. I think we have to understand that. And this is why I was saying that concept of human rights has been weaponized as colonialization by any other means. Now, those are harsh views, but those are very realistic views. And I guess with those comments, we will end today's seminar. Thank you, Ankit. And thank you, Ripudamanji, and thank you, Carl.
Thank you.
Thank you all.
Thank you.